I'm Paloma Capanna, and wherever Joe is. Joe, I want to thank Joe for inviting us to come here this evening to Safe Shoot. We are in Kingston, New York, for those of you who will be watching us on video. And also with us, Elmer LeSueur, Ulster County Federation. At the front table, Nadine Gazzola, who is the lead plaintiff in a lawsuit I will be talking a lot about this evening, Gazzola versus Hochul. And next to Nadine, Kevin Sisson, my much better half. And we do have some resources for you this evening, so I just wanted to bring to your attention. My website is 2ampatriot.com, and up at the front table we have business cards that also have my website address on it. And if you want to sign up for the e-blasts, which I send out very sparingly, so only when there is something important like a court decision or something filed by the state of New York, United States Department of Justice, and some of the other cases that I'm working on, feel free to come up to Nadine. You can either sign up on a piece of paper and we'll get you input, or sign up on the iPad and it will go straight into our system. My website also has a resources page with many documents that you can download for free. In addition, you'll find some white papers that I've previously written, including How Did Cuomo Pass the SAFE Act So Fast? I know, we're going to spend a little bit of time talking about the not so distant past and the governor that I never thought that I would say I miss. Okay, there you are. Yes, okay, yes. I'm with the right tribe of people if we are all laughing at that joke with a little bit of pain in our heart. Also upcoming, I will tell you, I have a new white paper that I will be publishing in July, focused exclusively on the Concealed Carry Improvements Act. We will be talking about that tonight. It is designed to be a risk mitigation handbook that will walk you through the statute, how it functions for private property, sensitive places, restrictive places, and contain an alphabetized inventory of all the places you cannot carry without express owner permission, or in some instances, there's no permission that's going to save you. So I've been listening for a year to everyone asking me 95% of the time questions about concealed carry, which actually is a subject that belongs to several other of the federal lawsuits in tandem of mine. And none of those attorneys having occupied that lane and me getting so many questions, I decided that yikes, there is still a lot of confusion over how to use that statute. So look for that coming out soon. What is available now, if you don't already have a copy, is the white paper that I published end of February, Hochul's War. And this is where we're going to be focusing this evening. Is we're coming up on the first anniversary of the 10-bill anti-gun package from summer 2022, and we'll be focusing here. This white paper is available for $15, and the proceeds go to support our lawsuit, Gazzola versus Hochul. I don't know how many of you noticed those bills go by in June. There was a tiny little ripple that made the news in North Carolina that had me pull it and start watching the tracking of what was happening, because for those of us who have anything to do with federal firearms licensees, one type of which is the dealer in firearms, the bill that hit impacting dealers was so extreme that it could only get worse from there, and that's when the CCIA hit. The bill that I'm referring to concerning dealers is the only one of its kind in the United States of America. It is also designed to put every dealer in firearms out of business here in New York. Governor Hochul is quoted standing in Yonkers, not far from Kimber, as saying there are no dealers in New York. She missed the boat. There are 1,791, a nice auspicious number, 1,791 FFL 01 and 02. So the type 01 is your dealer, or the type 02 is your pawnbroker. We do have 9 pawnbrokers left in New York under the O2 license. They are already nearly extinct. Make no doubt about it that while most of the conversation occurring in New York is around the CCIA, even at places like Nadine and Seth Gazzola's business, Zero Tolerance, or Joe's Safe Shoot, the bigger concern that I have is that without any dealers, the CCIA is completely irrelevant. Because I don't know too many people who have access to metal, who know how to forge a barrel. Some know how to reload, but not many. And so what good does your credit card do you in 2023 if there are no dealers? I mean, that's how we exercise our Second Amendment rights. We use our credit card. We go to the local dealer. So the conversation needs to get caught up in terms of importance, and it's very critical that we start to realize that the dealers are under an equal, if not greater, amount of stress as the individual. We are ground zero for this bill. If I can't hold this flank, you will see this bill proliferate worse than any kind of wild invasive species going through your garden. The CCIA, you see in other states already. Remember how the SAFE Act was also in Connecticut, also in Maryland. The CCIA also in states like New Jersey and Oregon. We're it. Gazzola versus Hochul is the only case in the United States of America, on the only bill in the United States of America, designed to put dealers out of business. Just to give you some idea of, this one notebook is my working copy of the papers that I have written. This is all double-sided, by the way. The papers that I have written just in support of a motion since our case began November 1st to try to obtain a temporary restraining order or preliminary injunction to stop the arrest of any dealer in New York while our lawsuit is pending, to try to get statutory sections, 31 of them, declared unconstitutional. It's over 100,000 words. And basically from about October, trying to think when Nadine signed the first affidavit, early October until first week of May, I did nothing else. I mean, that's it. It's the one case that I'm working on. There are no other cases. Just to give you a compare and contrast, a typical attorney in private practice, when I had a just full practice, generally you carry about 65 cases. And when you're doing constitutional law work, generally half a dozen, 6 to 8 would be typical. And I will tell you, this one case is more than a full-time job. The legislature passed it in less than an hour. Less than an hour. And the Republican conference did not even have the right questions, because of course there was never a committee hearing on any of this. There was never advance notification for any of us to go to Albany to provide expert testimony or to give them a markup of the bill, or even for someone like Nadine to pick up the phone. I mean, she knows how to call her assembly person and her senator and say, gee, hey, why don't you talk to somebody whose job it is, so that we can tell you the technical impossibilities of meeting compliance, the financial impossibilities of meeting compliance, and oh, by the way, it's unconstitutional as well. All right. If you get a chance to grab a copy of this white paper, one of the things that's in here that you may find to be a helpful resource is I do have an index of all 10 of the bills, including the bill numbers. I know Joe had just commented to me on the phone yesterday that without the list of numbers, it's actually quite difficult to research the individual bills. Some of them, like the body armor, was a separate bill. There are still dealers, when I talk to them about the body armor, they say, what process of applying for permission? So do try to be sure that you at least familiarize yourselves with a top line of what is in some of those bills, so that if you run into a situation, a little alarm bell might go off in your head to say, oh gee, I think Paloma mentioned it in her white paper, or I think I've read a blog on her website that talks about it. You know, let's find out, does it apply to me? Because sadly, you know, piece of free legal advice, not that you're asking, but free legal advice, ignorance of the law is no defense. So this is also part of what is very difficult. And it is difficult that the media really does not cover this for you or give you these numbers in the articles that they write. So a resource like this, even be welcome to make a photocopy, hand it out to the customers at your counter. I try to do as much as I can that is one page to make it possible to share information, because that is our best weapon, at least in terms of how I view the way that Albany treats us. I think that our becoming informed is our best weapon in response. Now, unlike the SAFE Act, where we had one lawsuit at the time, this time around, we have at least 8 major lawsuits that were filed by November 1st. And just taking them on a top down, Antoniuk versus Negrelli is the one I think most of you, if I said, you know, by a show of hands, are you familiar with the name of this case? The Antoniuk case? Half the room perhaps? Antoniuk versus Negrelli is, in a sense, the shorthand for the case against the CCIA. It attacks the most provisions, and the other cases, including the Bluer case, the Christian case, the Goldstein case, Hardaway, NYSERPA 2, because there is a second follow-up there versus Negrelli, and the Spencer case, all have a shorter number of provisions that they are attacking. So it is appropriate in terms of shorthand language when we're speaking with each other to be saying, what is the status of the Antoniuk case? It was first to file. It's the largest number of claims, and essentially the other cases, in a sense, fall behind it. They have not been consolidated into a single case. Judges do have the authority to do it. It was not done, but to refer to it as Antoniuk, you know, step first is fine. Those cases ended up at the Second Circuit Court of Appeals. So 4 out of the 8 ended up at the Second Circuit Court of Appeals March 20 for oral arguments. The Gazzola versus Hochul case was the 5th case to be there. Now, Gazzola versus Hochul, our primary focus is dealers. There are a couple of claims concerning the CCIA, but it really revolves around dealers and how they are functioning vis-a-vis the customer who is a concealed carry holder. Our case also argued March 20 in front of a 3-judge panel at the Second Circuit Court of Appeals in New York City. I would heartily suggest that you go to the Second Circuit website to listen to those oral arguments. You will find the link to that page both on my website and also in the white paper. And I also give a special shout out to the Jewish Gun Club, who has downloaded all of those oral arguments and reloaded them up into YouTube. So you can also listen to them that way if that's your easiest point of contact. Each side, so both the state defending and the plaintiffs, were given 10 minutes at the podium. My case was case number 5. We were the last one to go. And I will tell you, 30 years and being a woman over 50 and being from North Jersey and having a great pair of shoes. Great. Best pair of shoes ever in a courtroom. 30 years. Mine went about 31 minutes. So, you know, you figure I'm coming all this way. I got the only case in the country on this topic. I will be damned if you're going to put the red light on. There are literally 2 lights in front of the podium, a green light and a red light, like you're on a little motorboat in Lake Ontario, and they time it. Mine was read the whole time. The 3-judge panel for the first 4 cases concerning the CCIA, I do wish to commend. They were very well prepared. They had actually read the papers. They asked very good questions. And I am actually quite optimistic. Then the NSA, there we go. That when we get the decision, that it will be favorable to the plaintiffs. Now, famous last words, but I've been in the litigation game a long time, and I think it's incorrect to say you cannot ever tell the way a judge is going by their questions. The panel included Judge Eunice Lee, who is a very new member to the Second Circuit Court of Appeals, Judge Lynch, and Judge Jacobs. In theory, Judge Jacobs is our ringer, supports the Second Amendment. Judge Lynch, who everybody was saying was, the hardest and the most progressive and kind of all the rest of it, I said to Stephen Stambouli, who is the plaintiff's attorney in the Antonio case, I said, go back and listen to the oral arguments, because the questions that he was asking are exactly the questions I want him to ask. The other attorneys are on a slightly different tack than I am. Our case has a lot of citation to the communist pursuit in the 50s and to the socialist pursuit in the 10s and 20s. It goes to questions of, can you identify groups and simply push them to the side? And so this is really the tack that Judge Lynch was on. He was saying, well, could Macy's put up a sign that says no communists allowed? And it was wild watching the state's attorney freeze for like a second, and then, just wow, did she wiggle her way through that? But she didn't answer the question. And he knew she didn't, and he didn't let her go. And that's in part what it comes down to is, are we the next class of people being discriminated against? It's a kind of simple question, right? Can we simply be kept out? Because we've been through background checks. Because we have no criminal record. Because we have people who support us in our application for concealed carry. Because we may have been carrying already 50 or 60 years without a single incident. Can we be kept out? And that was Judge Lynch's line of question. So I'm all excited, right? I'm the 5th case. I'm listening to all these questions and I'm like, hot bench. I'm all excited. So I stand up. They had not so much as opened the cover of my papers. The assumption, think about the assumption. Dumb blonde, Trump girl, highly paid, representing the industry killing children. And that's exactly what I got out of them for the first 5 minutes. You go back and you listen to those orals. It's a good thing to be from North Jersey. Because all I could think is, Nadine Gazzola is behind me in this courtroom with Seth. Joe is there as well. How the hell am I going to turn around and go talk to my clients after this performance by you yahoos that you did not read my papers? Because you were just going to say no to me because you know you have to say yes to the CCIA getting gutted. I was going to be the fall guy. That's why I went 31 minutes. By the time I got done, they knew I knew that they had not done a thing, and shame on you. That's what being over 50 gets you, and from North Jersey, and great shoes, great shoes. I will keep those shoes the rest of my life. So here we are 90 days after oral arguments, and you're thinking, why is she going so long about this? Out of the 350,000 plus cases that will get filed in federal courts every year, 80 make it to the United States Supreme Court. The reality is, what the Second Circuit says is probably the end of the line for all 5 cases on our temporary motions. So it's not the end of the case, it's the first motion in the case. But in all likelihood, whatever we get out of that 3-judge panel in Manhattan is what we got. Now, I don't even know that we need the Second Circuit, so I'm not necessarily in a rush, and here's why. Nagrelli testified at the budget hearing in April that there have been 0 arrests under the new laws since passed. And as far as any of us can tell, and there is like an electric eel network all over the state of people watching, there haven't been any arrests, and there haven't been any dealer audits, and I'll take détente. I'll take mutually assured destruction in terms of 1980s nuclear game theory. Because in the meantime, we are keeping you safe. Just through not quite the means we would prefer. Gazzola versus Hochul has already been twice to the United States Supreme Court and both times been told, deny. One word. I'm killing myself. I had no Thanksgiving, I had no Christmas, I had no New Year's. I haven't even met Kevin's grandson yet, who is turning 2. He goes out to Utah, gets to play with Henry. I am pulling double all-nighters, trying to get stuff into the Supreme Court as fast as humanly possible. I get one word back, I get deny. Now, Antoniuk, and Stephen knows, I call this my jealousy piece. Antoniuk actually got a few words back. Some of you may have seen that when they denied their first application, one and only application, they gave a few words essentially saying, go back to the Second Circuit, do the full briefing, go do the oral arguments, and then if it takes them too long to render a decision, let us know, and presumably they'll pick the case up. But in Gazzola, we were there twice, and both times they simply said, deny. When the Second Circuit issues its decision, all 5 cases will have a renewed right of appeal to the United States Supreme Court. I do not believe any of us are going to be filing for what's called an en banc rehearing at the Second Circuit to go to all Second Circuit judges. I think we will all simply hope that with a 6-3 majority, perhaps 1 or more of the 5 cases will be taken up. But I will tell you that it's a complicated game, you know, who gets into those slots. I thought we had perfect timing on our Rule 11 emergency petition. So we were the only case where I felt we met the national emergency standard, because if you're going to start shutting down every dealer in New York, the Second Amendment is extinguished. Now to me, that's an emergency. That's absolutely an emergency. They didn't think so. The timing was great. We're coming to end of season, but it was a deny. So the best this is going to do is we get a Second Circuit decision. If it is adverse, all of us will have 90 days to file a petition for writ of certiorari to SCOTUS. That puts us already over into the fall. And they will then put us on what's called the Friday briefing schedule. You will see all of that publicly. Those are all public documents, including the scheduling. And then we'll see if they take anything. Now, because it looks like you're hanging on my every word, here's where it gets tricky for CCIA. I think they're going to get 65 to 70% of what they've asked for. And it's going to be death by 10,000 cuts. Because if you get the right provisions stayed, do you simply let the other ones go to the wayside? State of New York is not going to file an appeal of anything that they win in Antoniuk. They're not going to risk that a positive decision for the plaintiffs could be applicable nationwide, with other states also having a CCIA and other cases coming along, like out of New Jersey with Judge Bum's fantastic, again, decision. So New York is not going to file an appeal. But I think that that's, where they're going to come down to. For us, I think it's a little bit harder, because I don't know that they will even issue our decision at the same time as the other 4 cases. The other 4 cases have a nice relationship to each other. It is possible to issue a single decision if you want to. But then there's us. So let me tell you who we are. To keep. We are to keep. Of to keep and bear arms. 1791 to this minute, the word to keep has never been interpreted. Ever. In a decision. Ever. The words to bear have sucked the oxygen out of the room. My God, you go through the Federalist Papers, which I went through for like the 27 millionth time of my life during this case, desperately seeking, oh, come on, Madison must have said something about the word to bear. Because if you go through every draft of the Second Amendment prior to ratification, the only words that were never changed was to keep and bear. They've always been twins. They've always been joined. There's never been any other combination for the Second Amendment in its whole history from the minute of the first draft. And our entire case revolves around the interpretation of that word. So when I tell you that I've been writing 100,000 words, I'm telling you that I am trying to get the United States Supreme Court to accept my interpretation of the word to keep. It's a harder case than Heller, McDonald, and Bruin combined, because I got nothing. Now, that lights me up like a Christmas tree. I mean, look at me sitting up here. I'm like smiling away, right? Lights me up like a Christmas tree. I love nothing more than a blank page, because then we're talking about logic. There is still such a thing. Don't worry about that part. There is still logic going on somewhere. There is a Justice Thomas still on the bench. There is still some logic in America, right? And that's what I'm tapping into in terms of our federal legislative history for things like the Gun Control Act and for FOPA and for the new bipartisan bill and so forth. I mean, the fact simply remains that Congress has actually never infringed the dealer. We've always had a supply chain until this minute and this governor. Now, to me, that's a no-brainer. To keep is almost the simplest word to interpret because it's not encumbered by anything. But to a judge, that's terrifying. Terrifying, because judges are all about the slow, steady build. One little brick on top of one little brick, on top of one little tiny bit more, right? Heller, your right to keep and bear arms at home. McDonald, oh, that applies not only to your federal rights, but also your state's rights through the 14th Amendment. Nyserpa versus Bruin, oh, guess what? You have a right to carry outside your front door. Little tiny steps. And then here I come with this whole new theory of law and a word that's never been interpreted and has no history. And then you're almost thinking to yourself, dang, I got a book proposal that Tom Clancy would like. Because what does it mean that we are on the last word of the Bill of Rights to ever be interpreted in the history of this country? So I'm like kind of excited because I'm thinking, what are the odds that I got to do this case, right? I raised my hand without even thinking about what it was going to mean to Kevin and I and all of this and long nights and who cares, right? This is the most exciting minute in the history of the Bill of Rights. I can see 2 people, 3 people getting lit up about this. Hopefully the judges get lit up from the papers. So I don't care on some level whether they don't decide my case for 6 months or 9 months, which, by the way, is how long it took the Second Circuit for the NYSERPA versus Bruin decision before it went up to SCOTUS. So as far as I'm concerned, the longer they keep us, the better. Because just maybe, as Dr. Seuss says in Oh, the Places You Will Go, there's a chance. There is a chance. At the end of oral arguments, I'm a movie nut. I made a reference to Hidden Figures. I don't know if any of you have seen that movie. Great movie. That's your homework, in fact. Go home and watch it. It's a great movie. And without even thinking about it and without mentioning that it was from Hidden Figures, here I make this reference, and Judge Lee got it. I said, somebody's got to be the first. Our case needs somebody willing to be the first, to interpret the word to keep. And she got it. Her eyes twinkled. And I thought, oh, thank the Lord, right? Maybe we got through. Just maybe. You've got to have hope if you're going to work on the Second Amendment, ladies and gentlemen. And you got to have stamina. This is a marathon. I know a lot of you are frustrated. Why 90 days? Why aren't we hearing from the Second Circuit sooner? Indeed, several people who take far more questions than I do are calling me, what am I supposed to tell people, right? Well, you're supposed to tell them that it means the court is actually thinking, because statistically, and there are studies that people do on these things, the Second Circuit rules on average about 30 to 40 days, and we're just shy of 90. We're doing good. They're thinking about doing something they don't want to do, but that they know they have to do. Absolutely. So that's my sort of good news. I was actually hoping we'd get the decision like yesterday so that, this could be the first group. But I think, Joe, if it's okay with you, we're going to have to say, okay, when the decision issues, everybody go to Joe's website, go to my website. We're going to reconvene and we'll do a full briefing on whatever comes out, whether it includes Gazzola or it doesn't, so that we get you through. Couple statistics. SAFE Act, one federal case. 10 bill package 2022, we have more than 8 cases. SAFE Act, you had just a few individuals, 3 individuals, a couple legislators, groups, companies. This time you have more than 100 named plaintiffs in those 8 lawsuits. Last time we had Stephen Halbrook and Goldberg and Segella on the same case. This time more than a dozen law firms, several groups, Second Amendment Foundation, Gun Owners of America, New York State Rifle and Pistol, Gun Owners of America, New York. What else am I forgetting? Looking at Nadine. Firearms Policy Coalition. It's a much more thorough, both national and state response. The impact blast, however, is what I wanted to drive home on the numbers. So when the SAFE Act passed, I was the attorney who got the New York State Police to release the registry numbers. You may recall that lawsuit. And there were 23,334 individuals who registered 44,485 firearms as of June 16, 2015, out of an estimated 1 million such firearms in New York, according to the National Shooting Sports Foundation. Just in case you can't do math that fast in your head, 3% registered. Another auspicious number. This time around, though, just the CCIA alone, if I'm still working with NSSF numbers, you've got about 200,000 concealed carry permit holders in the state of New York outside of New York City. So think about that blast impact. Assault Weapons Registry, 23,334. Concealed Carry Improvements Act, over 200,000. I'm still a little bit confused as to how the number is that low, because I feel like I know more than 200,000 New Yorkers with permits, but For several newspapers, including the New York Times, the New York State Police are quoted as saying, we don't know how many there are, we just run the background checks. So I think that that leaves it as a summer project, and Kevin knows he's going to be signing it, that we do a FOIA to all 62 counties to ask them for their current numbers, and we try to get those numbers and publish them, because I'm a little bit not so sure it's 200,000, but nonetheless, I mean, this is an impact blast that is quite a bit more significant than the SAFE Act, just comparing two provisions, one against the other. Before I switch over to CCIA, a little bit about private property. Any questions so far?
I would think that the state police has records because we do the P12 forms. So not only has the county got the records for the county, but also the state does have their record. Now,
Sure.
if they're not keeping track and they're just having us do the forms, then that's that.
Nah, I mean, that's where the judge in Robinson versus Bruin, which was the lawsuit to get the assault weapons registry numbers, awarded us attorney's fees, which the state paid. Because absolutely, the New York State Police was not forthcoming in information to which we are entitled as a public. That, unfortunately, in this field of work, also nothing new. So going to the counties may get us both more accurate and timely information, and also be, hopefully, a little bit easier. Sir?
Yeah, just the problem you mentioned earlier about only 80 cases get picked up by the SCOTUS. Who is actually in the process of deciding which cases? I've been told that it's actually their clerks that go through those things and review them all and select and hand them off to the court, the judges.
No. Yeah, great question. So the question has to do with the process of how cert actually gets decided. And the answer to that question is the Friday briefing conference. So you can go to the United States Supreme Court website and just hit on the calendar button, and it will show you with a green box which Fridays they meet, and it's most Fridays, to discuss cases. So as a case comes into them with a petition for cert, there is a whole staff of clerks to make sure that the application is complete first. It does not move to the judges' desks until everything is complete. Then it goes to the judges. The 9 judges confer in the most guarded secret of American history in terms of how they vote. Whether it is a yay or a nay, you never know what the vote was or who voted which way, unless, like in the Antonia case, Justice Thomas and Alito actually scribe a few words that go with the deny. So for example, in Gazzola, we maybe had 3 votes, but not a 4th. But we don't know. So it's the hardest thing for me as a litigation attorney in federal court with this case in particular is that I've had already 5 rounds of litigation, and 4 times the only thing the judges have said is the single word, deny. I aim to please, I'm a fixer. If I'm missing something, tell me. So it's a challenge. There is a brand new book out also about the process that I haven't pulled yet called 9 Robes, and I'm interested to take a look at it. So that book deals simply with emergency motions to the U.S. Supreme Court, of which both Antoniuk and Gazzola went in that way, and both were denied.
You said you got 3 yeses?
No, we maybe we did. I don't know. No way to know. And that's the other challenge I think that we all face philosophically, is you're thinking to yourself, it's a 6-3 court, WTH, right? Like how are they not taking these petitions are so meritorious? Here's my best guess. The Second Circuit is notoriously not a supporter of the Second Amendment. Probably only the Ninth Circuit in California outdoes us in that regard. NYSERPA versus Bruin issues June 23 of 2022, and here already are 5 cases screaming to take precious 80 slots when they just issued a ruling concerning New York plaintiffs that the governor is bound as a matter of law to follow and doesn't. My suspicion is that they are trying to force the Second Circuit decision so that they can see how bad it is for us here on the ground in New York. And I think by them doing it that way, it may have helped our case with the Second Circuit. I think that's why Judge Lynch was so crabby on March 20th, is because he knows, right, that the Supreme Court is going to very highly scrutinize whatever they say. And so I think at the end of the day, they're probably going to strictly apply NYSERDA versus Bruin to the CCIA, which will knock a number of the provisions into a stay pending the lawsuit position. Whereas for our case, the Supreme Court really has to take us because there has never been an interpretation of the word to keep. It simply is fresh law. So we even have developed our own standard for adjudication that I dubbed constitutional regulatory overburden, to try to literally lay out what I would call a work against for them. So not only do I want you to interpret to keep this way, here's the standard that I want you to use, here's the outcome that you would reach if you follow my standard as applied to New York General Business Law, Section 837. Yeah, I'm not asking for much, right? I'm not asking for much. So we will see, right? We will see. CCIA, okay. I have done my best to avoid the CCIA like the plague. I'm just going to be completely candid with you. When Bill Robinson of the Second Amendment radio show called me and said, could you just do a little memo for Stephen about the CCIA? So I start typing this memo and I'm going, you have to be kidding me. What is this? Is this a joke? This can't possibly be a bill that's actually passed, right? So I'm typing this memo and I'm like, Bill, this is a complete dog. The statute's going to fall. Just get the suit filed. You know, this is so simple. Because, of course, I'm a believer in the Second Amendment. So for me, this is like, I don't need to drink the Kool-Aid. I'm looking at the statute. The whole thing fails. Having passed that over to Stephen, I'm thinking, fantastic, I don't have to look at it again. Because in North Carolina, we got open carry, you know? We've got, you walk into a gun store, and the first time I walked into Nick's Guns and Gear, which is our local, he looks at me, the other guy behind the counter, Steve, looks at me, and they start laughing. They're like, which state are you from, New York, New Jersey, or Connecticut? Because I freeze. I'm like, this is illegal. You have assault weapons. This is, oh my gosh, I can't be in here. You have banana clips. I can't stand in this FFL, right? He's like, come in. It's all legal in North Carolina. Oh, thanks. Thank you.
You're welcome.
You know, and so it sort of gets famous from there, from the standpoint that part of why I'm so glad we moved to North Carolina is it really has me living what we should be living in New York. So I know what it feels like to live in a free state. I'm from New Jersey, then lived in New York, now North Carolina, and I just want to bring North Carolina home to y'all, as we say in the South. So imagine, if you will, March 20th, all 5 attorneys at the podium have addresses south of the Mason-Dixon line. So I'm telling you, if you reach the end of your rope in New York, come on down, y'all. Come on down. Come on down and be free. Here's how to think about the CCIA. Just take a deep breath. If I'm going to give it to you in the name of risk mitigation, you simply leave your firearm at home. That's the only way I could guarantee you under the CCIA that you won't get arrested. Forget everything you've ever known about property law, because the presumption now is that you need permission to set foot on private property. And private property now apparently includes retail space, which last time I checked is when you're open to the public, the 14th Amendment applies. And we are all equal, whether we want to make cupcakes or concealed carry. Not in New York. Not in New York. We have our home in Keene Valley in the Adirondacks. Now, when you drive there, it says Adirondack Park. Welcome to the Adirondack Park. So we have the bill that passes July 1st, 2022. Then we had what are called technical amendments to several of the statutes in Section F of the very last version of the budget bill. Supposedly, that meant the CCIA is now exempt from forest preserve lands in the Adirondacks and the Catskills. We live about 2.5 miles from an independent coffee shop that I really like. Iced caramel lattes, Old Mountain Coffee Shop. If you're on 9N, stop in. Fantastic place. This morning, I hired myself, because I'm working on the white paper on the CCIA, so I'm far enough into it, I hired myself. Ring, ring, Paloma. Can I leave my house and go to Old Mountain Coffee, 2.5 miles away, carrying concealed? So, I pull out my notes for the CCIA white paper, in which I have this absolutely fantastic, alphabetically done section. Parks. Parks. So I've got the statute there, and I'm looking at it, public parks. Then I'm looking at the reference to except subdivision environmental conservation law, section 9-0101. Forest preserve, and there's a definition. So I happen to be on the NCOM website when I'm looking at this in the first place. It just was the first Google result. Oh yeah, let me take a look at the statute there. But good thing that I clicked through to the actual statute, because the NCOM website doesn't actually have the full statute on there. Just in case you start there, there's further subdivisions A, B, and C to that statute. So by the time I got done clicking, I realized, well, to read section 9-0101, you have to also read section 9-0107, and you have to read section 9-0501. And what you end up with is the definition of the Adirondack Park, and the definition of the Catskills Park is actually the coordinates for the survey map. Now, I don't exactly know where my house is within the survey map. So I back up to the NCON website. I'm thinking, well, all right, I'm an attorney. I can make a defense using the NCON website, and it says Essex County. All right, so there's my county, so I'm thinking, all right, I'm going to rely on this. Mind, I haven't set foot out of my house yet, and I'm, how far? 37 minutes. And trying to figure out the definition of where I live just so I can walk out the door. But I live in a subdivision called Adrian's East, and I'm thinking to myself, how does that fit in the scheme of this? Do I need permission from my neighbors to go down the road? Okay, then I remember, as long as I keep driving, I'm not technically stopped under the CCIA. I'm not technically out of my car. All right, so I can drive through my neighborhood, down the hill, from. Okay, but accepted under the CCIA are towns. Towns, even when you're in the forest preserve, towns. So at the point that I get to this little tiny strip known as Keene Valley, where there's like, half a dozen little stores, apparently the CCIA applies there. Okay, then I want to go to the coffee shop. Well, the coffee shop doesn't have a sign hanging up. Y'all are following me, right? Now you have to see a sign that says you are permitted to enter concealed carry. Not the opposite of what it's been for the last however many decades you've had your concealed carry permit. Okay, I know there's no sign on the 2 doors to go into this house with the coffee shop, which is rented. They can't give me permission to enter the property to get to the shop. They can only give me permission to walk into the shop. So what have I got to do? Go to the deed? track that guy down, who for all I know is in Florida, because let's face it, it has been cold in the Adirondacks the last couple weeks. Then do I have to get permission in writing? What if I think I have permission over the phone? I go to the coffee shop, Steve, who's a pretty cool guy, says, yeah, come in concealed, that's fine. And all I got is an audible. Well, should I have my attorney call so that the attorney can then write a protect yourself letter where the attorney says, Dear Steve, thank you for giving my client permission to enter Old Mountain Coffee while carrying concealed. We appreciate your courtesy. Risk mitigation. This is my entire career is about risk mitigation, and I can't figure out whether I can go 2.5 miles in the Adirondacks to get a cup of coffee from my house if I'm carrying concealed with a permit already issued by the state of New York saying you passed the background check with flying colors, you have no criminal history, no federal disqualifying factor, no New York disqualifying factor, etc. It gets more comical, as you go through different scenarios. That just happened to be, if you will, the most immediate one that I was working through. Others of the plaintiffs, because there are several plaintiffs in the Antonia case, one of them is a firefighter in the Catskills. And his question to the court is, I respond to a fire call, you want me to what? Ask the owner's permission while the house is burning? Do you mind if I concealed carry while I'm fighting this blaze? Or do you want me to disarm to my car and take the time to do that and store it and then proceed to fight the fire? So the scenarios that are put together in the Antonia case are the very day-to-day lives that we've been living. And let's face it, why do you concealed carry in the first place? Sure. Just yourself? Would you protect me?
Absolutely.
Do we know each other? Oh, we do? Oops. Is there a stranger in the room who would protect me? No. I mean, you see my point. I wouldn't care if somebody was a bleeding heart liberal. It's another person. I don't expect them to carry a firearm if they don't want to. I don't expect them to get training if they don't want to. And I probably expect, given human nature what it is, just get behind me. Just follow my lead. It's lost, however, in this Albany. We're up against someone named Hochul who may have been from Buffalo, who may have had an NRA A+ rating when it suited her running for Congress. But she is not that Hochul anymore, assuming she ever was. And so where we are stuck under the CCIA is me saying to you point blank, don't volunteer to be a criminal defendant. Please don't. I get that question, and I got it a couple days ago in earnest from someone. If you take a look at these lawsuits, what you will see, both in the Antoniak lawsuit and in the Gazzola lawsuit, is we have plaintiffs who have already pled that they either are or intend to violate the law, and that is enough for now. Don't be that defendant. Yes, it's a stronger case. I mean, I'm not going to mince words with you. Is it a stronger case? Sure. It's a different path to the arguments of unconstitutionality because of standing. And we all get that. We all know that. But to completely convince you of this point, let me pull a Mary Poppins on you. Do you know who Stuart Rhodes is, who I mentioned at the beginning of my remarks, founder of the Oath Keepers? He is now incarcerated for the next 18 years for never having set foot in the U.S. Capitol on January 6th. This document right here, which was just published May 5th, is 183 pages that I have to brief on. You'll see a blog about it shortly. This is what the United States Department of Justice filed against Stewart Rhodes asking for a 24-year prison sentence. And you have to understand that pre-sentencing memorandum can contain hearsay, and this is rife with bullshit. Unsupported, unsubstantiated, uncited, not even tried to be admitted during the trial because it wouldn't meet rules of evidence. And Rhodes got 18 years. So what you have to understand is that for someone like Nadine, someone like Mr. Antoniuk, they're facing potentially felony E or misdemeanor A charges. You do not want to be in that position. That is why a dozen different law firms are fighting like hell to try to get an actual judicial stay so that arrests can't be made while we are then focusing on things like the phase of discovery and putting on a trial to get these statutes permanently declared unconstitutional and off the books. It's a hard risk. To the other comment that I get, which is we were better off before NYSERDA versus Bruin, arguably yes, in the state of New York, because the backlash was wild, but without NYSERDA versus Bruin, we can't even file these cases. We absolutely had to have a U.S. Supreme Court decision that says you have a right to carry outside your home. Absolutely. Or there was really no basis yet established for the CCIA. So NYSERDA versus Bruin puts all of you as individuals on a strong footing that we are still trying to establish for the dealers in the Gazzola case. So it puts you ahead even if you feel like you are behind. I'm hoping I'm able to get that sort of point across. It also created positive results in probably 40 to 42 other states. So for a state like North Carolina, you made North Carolinians more free. For right now, that has to be the consolation prize, because we are going to have to suffer through this for a little bit longer together. And recognizing the possibility that we don't make it to the Supreme Court, and we've got to slog through the rest of this case, which could be another year to two. I know. I'm with you, brother. Like, if I could hug you and you wouldn't then call me a liberal, fist pump, whatever, right? One should do in this situation. The average Supreme Court case in U.S. history is somewhere between 3 and 5 years. The longest ever, Dred Scott, he actually passed away, but he won. It's a big issue. Try to focus, if you will, on what we can do. So what can we do? Education of each other. Absolutely. Love your FFL, right? We've got the stickers, right? Love your FFL. This is the campaign I'm trying to, get people to buy into. Go to the FFL and at least buy a t-shirt. Go to the FFL and buy your 100th pair of earplugs, right? If you have concerns about your handgun purchase or an ammunition background check, which hasn't yet started, right? Take whatever path you need to take on the conservative road to feel that you are in a good way, but we have to support the FFL dealers. They're really your front line in this at the moment, and we can't afford for them to go out of business because the business is down. So I understand, tricky, but don't take it out on them because they definitely didn't want this law any more than you did. We also have to turn the corner on recruiting attorneys. Your probably least favorite word. We are so far behind the other side concerning attorneys. If New York State starts arresting, we do not have the criminal defense attorneys ready. So I need you to be going out and meeting with attorneys, talking to them about your circumstances and concerns, identifying yourself as a concealed carry permit holder, and asking them if they would be capable of defending you if you do get arrested. When I put out the CCIA white paper, I actually have a section on basic credentials of an attorney that would be helpful in that instance. I will also have in there a list of all the names and addresses of the attorneys currently representing plaintiffs. Most of us do not do criminal defense work. Most of us are on the civil side of trying to get ahead of the arrest piece. So this is the other reason, really, that we need you to get out there and be talking to attorneys, tell them this is a real thing, they need to be gearing up on it. We've got a pretty good number of attorneys at the county level who do things like your concealed carry defense or submission. Those are the same attorneys we probably have to try to now recruit to be doing some of the defense work. Why I say that is because, and I did lay it out in the Hochul white paper, the other side in 2016 and 2017 has managed to get some of the top 200 American jurisprudence law firms to pledge tens of millions of pro bono hours, firms like Skadden Arps. And we just don't have that on our side of the fence. Every town, Giffords, look at their Form 990s. Look how many attorneys they're paying hundreds of thousands of dollars a year as a base salary, full-time to work in-house. We don't have that. There simply isn't any national organization with in-house attorneys that represent plaintiffs or defendants. NRA has an in-house staff, but they're largely advisory. They're not courtroom attorneys. So we do not have anything comparable to what's going on the other side. 2016, 2017, huge pivot on the other side. We missed it. We missed it. As part of why you see, for example, lawsuits of the government of Mexico suing U.S. manufacturers of firearms is because look at who is representing them in those cases. U.S. attorneys. This is not Mexican attorneys, this is U.S. attorneys suing U.S. companies, triangulating the Mexican government to be the plaintiff. So we've really got to work on our ground forces, and sadly, getting more attorneys in your life is a little piece of that. Other than that, let me know where I can come out to be speaking to you. We'll be up here full-time at least until Halloween. I know a lot of you have monthly meetings at your rod and gun clubs and so forth. You know, let me know if we can come out and do education seminars. Tonight, we're doing something a little bit different. We're a little bit more in-depth on some of the more difficult aspects of the issue, but I can do things that are a little bit more general public friendly as well. Other questions, and we'll just take a break for a minute, and then we'll do a little bit more on the dealer side of things. Yeah?
So this whole thing, I have no legal experience. You're an attorney, but this whole thing sounds very subjective to me. You know, it sounds, it's open to interpretation. You might get a judge, if you get arrested, that maybe is lenient. You might get a judge that throws you in jail for a few years. Depends upon the arresting police officer. But my main question is tonight.
Yeah.
Is it legal? I have a permit, had a permit for 47 years without a problem. 47 years. And I have to be put through this BS. But is it legal for me, tomorrow morning I want to go to the store and there's no sign of that store. I understand, as I understand you, it's illegal for me to carry my gun to that store.
Yes. Currently, yes.
And that's any place in New York State. Without a sign on that door, you legally cannot enter that business or that residence. And you also mentioned about property. So if you're hunting on somebody's property, deer season, and you want to carry your handgun, you have to have permission from that person to carry your handgun on their land?
Private property, I would say yes.
Yeah, that's what, That's
right?
what you mentioned before.
Yeah, and where the spin on the retail comes in is, that's just completely backwards. The whole thing is just completely backwards. So what makes it hard is that you almost have to take everything that you know and then consciously flip it upside down. Now, according to Hochul, there are a few streets where you're still permitted to carry. A reporter literally said to her last summer, "So where are you still permitted to carry?"
Right.
And she said, "I'm sure there's a few streets somewhere." Because the restricted and sensitive places goes on and on, A, B, C, P, D, Q. It goes through how many different categories? There's like 40 different categories. And I've been asking for a year, maybe one of you in the room can do it, I'll keep asking, for someone with the technological skill to do an overlay map. So what I thought would have won the day on the CCIA case is start with A, on the map of the state of New York, make it red. Those places, make it red. Then go to subdivision B. Make those places red. Go to subdivision C. Go to those places, make that red. To my best guesses for Onondaga County, which is where I manually did a map overlay, I do think you're only left with about a half a dozen streets that actually don't qualify. Assuming that a couple of my readings, like the OCFS licensed centers, which would be every single licensed daycare in the state of New York, I couldn't find a list of every address, but I'm assuming there's approximately so many spread in, the suburban areas. That's the map that I thought, why bother to write anything about the CCIA? Put up a map, and keep pulling one more piece of colored tissue paper over the top so that the judge could see. It's not about whether you can go to the Rosamund Gifford Zoo. It's that you can't go anywhere in Onondaga County if you're going to carry concealed and get out of your car and leave your car. Now, if you keep driving, by the way, if you keep driving and never have to go to the bathroom and never have to get gas and never need groceries, just keep driving, then you're okay.
What if you
So-
get pulled over?
Yeah. No, you're okay.
Concealed carry.
Yes.
I'm warning my customers that they cannot carry a long gun when they're hunting and park off the road because now they're on private property. Okay, it's not just concealed carry. The law is written, as I understand it, and I'm not a lawyer, so.
Yeah, that's okay.
But the way it's read is you cannot carry a firearm. It doesn't say a pistol, it says a firearm. So,
Yeah, and
if
the,
you're a hunter, and I have mostly hunters that come to my store.
The slight disconnect there, and you raise a really good point, thank you for reminding me to make this point of clarification. For those of us who do federal firearms compliance law, we operate with a particular vocabulary set out in federal statutes and ATF regulations. It does not match the New York State vocabulary. So I never, even in my paperwork, what I did was right up at the front, I informed my judges that I am using federal definitions so that, because it's just so much easier when you're talking about the rifle, the shotgun, the handgun, firearms, and toto. It's just clear. Why New York State could not simply incorporate those federal definitions so that we had something consistent to talk about. And I agree with the fair lady that, there's an argument there, but good hunting would always dictate that for any private lands you don't own, you have permission before you hunt there. So, yes, I have a gentleman behind you first, yeah? Go ahead.
Technically, if you have a New York State hunting license, and you're in the Adirondack Park, you can hunt with a handgun because it gives you legal jurisdiction.
Yes, and so this forest preserve definition is an exception to the CCIA, but there are multiple layers of exceptions beneath the exceptions. So you've gone hunting, you're sure it's forest preserve land, but then you decide you want lunch. The CCIA applies. It is not an exemption for the entire park and everything in it. It is only for the approximately 2 million out of 6 million, I think I'm getting the ratio right, acres that are forest preserve as opposed to town properties or any of the other 40 categories of CCIA applicable prohibited places. That's what I'm saying about it just being a crazy mishmash.
Nobody has the right to search you, not even a state trooper, if you're carrying concealed, unless somebody sees you.
Okay, so let me give you my one caveat here, because most of you, I think, are new faces to me. We're about to become best friends, or you're never going to talk to me again.
No,
Let me just tell you what I call that. Don't get cute. Here's why I say don't get cute. That wouldn't fly in a courtroom. I can't sell that argument. I'm not going to be able to protect your permit with any of my county judges on that argument. Why? Because you knew. You knew. You knew better. That's how you got to 47 years. That's how you passed the background check to get the permit in the first place, is you knew. That's what I mean about risk mitigation under the CCIA in New York. The goal here is protect the permit. It was hard to get it, and if you lose it, I'm going to tell you right now how much harder it is to get it back. Yeah.
So, real quick question. I know we're trying to protect the permit. Is there any lawsuits within New York State right now with the semi-rifle endorsement on that permit? Because that was a semi-rifle,
Yeah.
and that was our pistol permit. Is there any lawsuits right now to help us dealers stop that?
Gazzola versus Hochul, that's my case. Yes, yes. So in part 2, I'll touch on that point, along with a few others. But I wanted to see if I could get everybody kind of this far before really wigging you out on what your dealers have to go through. And listen, it's not to say that if you're doing your best and something goes wrong, and you do get pulled over, or you do get arrested, or you do get charged, that you're indefensible. It's simply to say this: risk mitigation is, how do we get as many people across the river as we can? Because 200,000, if that's correct, if there's only 200,000 concealed carry permit holders in New York, that's not a lot. That is not a lot. And so when I say to you there's 1,791 dealers that are reflected in the lawsuit, Gazzola versus Hochul, and you look at the number of New York State police officers, we could be wiped out easily. That state license renews every 3. You could see dealers go extinct in 3 years. We will find out very shortly. So dealers have 2 licenses in New York. They have the ATF license, renewable every 3 years. New York State license, renewable every 3 years, not on the same date. It's going to be a month, 2 apart-ish. So we've had 2 of our plaintiffs renew their federal licenses with a particular application packet that we submitted that included pleading the Fifth Amendment about whether they are in compliance with New York State laws relative to the laws challenged in this case. The first one took a little while. Thank you, Nadine. The second one, with the same packet, went through very quickly. So we've got 2 of our plaintiffs through their federal renewals. The first of our plaintiffs has to do his New York State renewal next month. My optimism is, what, 3%? That we're going to get him through that New York State license renewal. And in New York State, if your New York State dealer license does not renew, you cannot be open. Your federal license is insufficient in New York. So the logic is fairly simple. Protect the federal license no matter what. Because if you are closed in New York, you could still operate your business in another state. Not the outcome people want. But I'm always about options and opportunities. At some point, this all shakes out. We've just got to get as many people through it as we possibly can with as little damage as possible. That's really the name of the game here. 1,791 dealers and pawnbrokers, 200,000 of you with concealed carry, compared to a population of the state of New York, 45% of which lives in the 5 boroughs of New York City. But we can do this. You don't have to be a big guy to win. Look, Gideon versus Wainwright, it's my favorite case. If you don't remember it from high school, I'm sure everybody heard it at some point. The right to an attorney came from a man who was incarcerated and wrote a 1-page, with pencil, application from his jail cell to the United States Supreme Court. They did not even let him be present in the U.S. Supreme Court to argue his case. The U.S. Solicitor General was brought in to argue on his behalf. And he established the right to counsel for all of us. You do not have to have big money in America. You have to be on the right side of the Constitution, and we are. It's that simple.
Then how come the governor can do whatever she wants against the Supreme Court? She rules they can't conceal carry in New York. She ruled against it.
Yeah, but this fight ain't over.
She swore on
This
it.
fight ain't over. Governor Hochul is as close to a Dixie Democrat as you're ever going to find in 2023. I have one little quote of hers in this white paper. Let me see, I put a thing on it. Hochul quote that I wanted to just remind you of in case you hadn't heard this one. So Hochul said, "The Supreme Court decision in Nysurpa versus Bruin was certainly a setback, but we view them as only temporary setbacks because I refuse, as I've said from day one, I refuse to surrender my right as governor
Exactly.
to protect New Yorkers from gun violence or any other form of harm. We're not going backwards. They may think they can change their lives with the stroke of a pen, but we have pens too. I give out a lot of pens, and that draws from the office of the governor of the state of New York." Who is she quoting? Who is she quoting?
Obama.
No.
He said he had all the
Nope. Governor Orville Fabus, 1945, who said, "No school integration." The governor did not have to follow the U.S. Supreme Court. And what did it take? Brown versus Board of Education 2. There are 2 Brown versus Board of Education decisions to create fully integrated public schools in America. Yeah.
Most of us don't know anybody as involved in this kind of cases as someone like you. So we get our information, internet,
Yeah.
friends, that's everything. If you took your crystal ball and unclouded it a little bit, where do you think we're going to be 3 years from now? 4 years. I mean,
I'm just winding the calendar. So 3 years from now is another presidential,
Living in Florida.
which we win, taking a supermajority in the House, a solid majority in the U.S. Senate, still a 6-3 U.S. Supreme Court. Hochul's coming up for re-election, but this time loses, because even $60 million in her current war chest, breaking whatever record she supposedly broke. Does Zeldin run again? Would you vote for him if he did? Are you all committed to voting the Republican line no matter who's on it? Where we probably are is Second Circuit does its job for the CCIA and guts the lawsuit, guts that statute. Gazzola versus Hochul makes some gains short term. All of us have to go the distance. We win. And guess what? New York State enacts the next POS legislation. You can decipher that acronym for yourself. But we will be so much more sophisticated 3 years from now with who is currently on the ground, combined with what we did after the SAFE Act, that we will start to level out and New York will become a less important battleground for anti-gunners. That's where we've got to end up, is that we become a state that they realize they cannot have substantial gains at no cost. 50 million sounds like a lot, but remember that they are also paying people a lot of money. If you look at those Form 990s in terms of who they have on staff and the amounts of expenses they're running, it's not like they're generating some massive reserve. They're spending it like water, right? So they're going through their money fast. We're being smart and fighting lean. We will attract more attorneys. We will attract more people like yourselves. And Joe is hoping that we even get ourselves a little bit of a New York State FFL consortium group where we start to talk and we simply start going back to Albany. We used to have legislator days. O'Mara and Barkley, why are they getting off so easy from us this time? Even if you feel like you're banging your head against the wall, those people should be on speed dial, right? Call every day. Repeal General Business Law, Section 837. The little green card. 875, 837, right? Grab one of those green cards, keep it in your wallet. Grab two, give one to a friend. The back of it is each little step to go ahead and do. Start talking to your neighbors across the fence. Donate $20 a month to the Gazzola lawsuit, if you can. We do have to start thinking longer term. We do have to start developing something like what we were talking about 5 years ago, like a legal defense fund. From my standpoint, I'll continue to put as much information up for free downloads as I can. Please beat up my website. If there's some document you're looking for and you don't see it, email me, right? Let me grab that document and put it up, because you're probably not the only person who's looking for it. The CCIA white paper, I intend to include a page that is a sign that will be legal compliance. Make 57 photocopies and walk to every business in your neighborhood. Say, please, would you post this? I have yet to see a sign in any business inviting us to come in as, do you have one?
Tractor Supply Partnership.
Yeah, all right, good. I'll have to go take a photo and, make a blog post of it. But we need to be telling business owners, we are your customers. Invite us in, right? Yes.
So, local business, private, whoever posts one of those signs, and crap hits the fan, somebody comes in.
Yep.
Concealed carry or legal or otherwise, is that property owner, that business now liable and suable and held accountable because of that event? They gave permission for somebody to walk into their premises with a firearm, and that firearm was discharged and caused whatever it caused, that action. Is that property owner who gave permission by that signage now also able to be sued in court criminally or civilly?
I don't think it's any different than it was prior to summer 2022 or in any other state where you don't have to post,
I see it.
right? All that's,
More greater. You have now, before it was just you could go in with that. You had to say, no, it's not allowed. Now you have to say it is allowed and you are expressly giving permission, and now something does happen.
But the other was implied permission. It's not really any different.
Okay.
Yeah. I mean, why are we not seeing more signs? Who the heck wants protests outside your business? I mean, we all know why the signs aren't going up. And I think there's a lot of businesses out there that are tacitly could care less if we're coming in concealed carry, given robberies, given various neighborhoods, etc. So, but it's a tough thing. It was like with the SAFE Act, and everybody would say, oh, I didn't register my weapon. I'm like, don't tell me this. You're not my client, right? There's a lot about the SAFE Act that I've never heard of a single arrest under any number of the provisions. The problem is once it's on the books, it's on the books. And so a more sophisticated strategy, sort of 3 years out to your point, 3 to 5 years out to your point. I mean, we need to start to have briefing guides that we're giving legislators that these are the expected provisions that need to be repealed. End of sentence, right? They come in, they want to talk to our groups. Here's the checklist. Will you sign the pledge? to take the actions. Affirmative actions. I don't care that the Republicans are in the minority, you can still number a bill. Let's go, right? Where's your statement on the floor of the House? Where's your statement on the floor of the Senate? The questions that they asked in their allotted few seconds about the CCIA, I invite you to pull the transcript. Complete ignorance. Complete ignorance. We had like one person say, oh, I'm a concealed carry holder. The other questions were just simply foolish and a waste of time. So we've got to get people better prepped. There's steps to take. So you will need to get up with Joe. So Joe, this gentleman and you are going to become good friends because he'd like to know where we're going to be in 3 years. Let's get him together as part of that discussion. I'll do one more, then I want to make sure to give everybody a break for a minute.
I do have a question for you though. Like, do you remember, or where were you? What state did you live in for the SAFE Act? Were you in New Jersey or you were here? So when
Do you not remember all the lawsuits, the TV appearances and so forth?
I remember the gentlemen, they came into our town, Albany, West, Buffalo. Hey, I need money, I need money, I need money. That's all he kept saying. We gave him money. As soon as we give him money, we didn't hear nothing of him, except he kept giving us mailers saying that he wanted more money. And then as dealers in New York, we still got the end of the stick because now we have to comply with all the AR regulations. So what did that money get us when we kept donating our money to the SAFE Act? So
I'm not sure who you're talking about, other than it wasn't me.
Right, it wasn't you.
Okay.
No, we're not blaming you at all. But here we go again.
Yeah.
Individuals going throughout the state of New York, hey, we're going to work on dealers, we're going to do CCI,
Yes.
we're going to do all this stuff. The same concept happened during the SAFE Act. Come right around the state, hey, we need your support, we need your money, and we did all that, and what did we get?
I actually have an answer for you. So this is perfect. So, I'll take your $20 right now.
The SAFE Act?
Hang on, let me answer the question. So the answer to the question in Gazzola versus Hochul specifically, which is my case, is you're writing history. So what we are doing right now with every single piece of paper that I submit, all of which is a public record, is we are saying to lawyers all around the United States and US territories, there is another lane. There is another argument to be made. Come make it with me. Every single case that I have had since coming to the Second Amendment full time has been new lane. And cases that previously I had, like Robinson versus Session, which was the NICS to TSDB connection case, is actually starting to get cited in other cases by other lawyers. So I'm very conscious as I'm writing these papers that yes, I'm writing directly to my judges, always write to your primary audience, but all of the citations, all of the research, all of the structure of the arguments is the handbook for the guy behind me. And we have to get news of this lawsuit out. Because I think it's the sexiest thing in the court system this entire term, bar none in terms of topics. I can't imagine a better case. But it's also the biggest case nobody's heard of, except for the New York Times, Forbes, USA Today, and everybody else quoting me, including Fox. They're taking quotes right out of the papers verbatim. You're not going to find my name too much if you Google Gazzola, because they're putting in the case name and they're taking quotes of the arguments that we're making, and that's a huge part of the win, is even getting people's minds open to the role of the dealer and all of the amazing things that you do every day as the front line of the background check system, and how it relates to the Constitution. So for this 1 minute, that's my answer to you, is every single word here is precious. I'm a little biased. It's my favorite case ever. Don't tell Bill Robinson that, but I think that what we're doing is fairly exciting in that regard. And certainly on my agenda list is how do I get into some of the southern law schools. Northern ones won't have me, I've already tried that. completely struck out in New York, not a single invitation. I tried more than once. But get into some of the more conservative southern law schools and really fight fire with fire, because the Giffords and the Everytown and the Brady lawyers are in the law schools giving lectures. They have continuing legal education courses for lawyers. $125, 2.5 hours. They just released this in April, this spring. How to Sue Gun Manufacturers for Profit is the name of the course. So, I'm trying. I'm a one-woman army. I'm doing my best. Doing my best.